Thank you, everyone, for joining us. Good morning to those of you out west, and good afternoon to those of you farther east. My name is Dan Balkaran. I'm a lawyer at the law firm of I'm an employment lawyer at the law firm of Samfiru, Tumarkin, and I'm going to be answering your employment law questions today. Before I start doing that, as always, please feel free to go to employmentlawyer.ca for any questions you might have. If you need to contact us, you can email us at help@employmentlawyer.ca. You can always call us at 1-855-821-5900. And also there you can get quick answers to some of your employment law questions right there. You see it on the screen, pocketemploymentlawyer.ca. Okay, so while I'm waiting for your questions to roll in, I'm going to, I did one of these last week, a Q&A session with all of you last week, and almost all the questions were about mandatory employer vaccines. So I'm just going to give you a little primer right now on what they are and what they aren't, and hopefully that answers a number of your questions, and then I'll just get into specifics, because it's not just the hot topic, it's really the only topic for anyone contacting us right now, or for vast majority of people contacting us right now with respect to employment matters. So okay, so what when I talk about mandatory vaccines, what are they not? Mandatory vaccine policies from employers, what are they not? Well, what they're not, and what I'm not going to be commenting on at all today, are the vaccine passports that are being implemented in places like Ontario and British Columbia. That isn't an employment matter. It is a political matter, and I certainly don't have any specific expertise on that. Okay, so what are they? Well, what we're talking about is employers who are implementing mandatory vaccine policies and saying by X date all employees have to be vaccinated or face termination. And so, people are asking us, well, what are my rights in that situation? And another way of asking that question is the employer at law permitted to implement a mandatory vaccine, right? And the answer in almost all cases is no. They have no legal right to do so, but it really, you have to look at the practical effects of what the policy is. And so if your employer says to you or says to its employees, you must get a mandatory vaccine, and if you don't, we're going to terminate you. If you refuse to get the vaccine, they're going to terminate your employment. Okay? And there's no, I don't have any magic today that can stop them from doing that. All of your rights with respect to your termination of employment are after termination. And really the short answer to that is your only legal right in the event of your termination is severance. Okay. And so when you're deciding whether or not to get a vaccine, you have to, it's an intensely personal choice, obviously, if you have hesitancy about getting the vaccine. But if your employer says you must get the vaccine, then you should weigh your own personal beliefs, your medical situation, and it may also be incumbent upon you to weigh what your potential severance rights are, and you put those all into a pot, and out comes your decision on the other end. But just because your employer has no legal right to terminate you for not getting a vaccine doesn't mean they're not going to terminate you anyway. So you're still going to lose your job, and so that's something that you need to think about. And so when I say they have no legal right to terminate you, again, all your employment rights come after termination. It's, your only legal right in the event of your termination is severance. And the real question for the purposes of our discussion today is, can your employer terminate you for just cause for not following a vaccine mandate and sorry, I'll rephrase that, for not getting a vaccine that the employer has deemed mandatory in its policies? Just cause means that you don't get any severance. And the short answer is no. Almost in all cases, you will be entitled to severance, and how much severance you're entitled to, which may inform your decision about whether or not you're going to get a vaccine, is pursuant to a number of things, including what your employment contract says, your age, length of service, and the position you have at the company. So that's sort of a quick primer on your rights with respect to mandatory vaccines. I will also say it is highly possible, if not likely, that the termination, if your employer terminates you because you did not get a vaccine, you also might have been discriminated against on the basis of a perceived disability, and you might also have a human rights claim, which would lead to give rise to human rights damages. Okay, I'm just making sure that I've covered off everything before I jump into your questions. I did this, as I said, last week, and I saw there was a question that came up in the YouTube comments. I'm just going to address it now before jumping into your questions. So I talked about last week about how if your employer if your employer terminates you for just cause refusing to get the vaccine, but provides you, or let me phrase that a little differently, your employer says to you, we're implementing a mandatory vaccine policy, you must get the vaccine, or if you don't get the vaccine, you have to get testing every week, COVID testing every week or every 2 weeks or whatever the interval is. And, I said that, it can't force you to get the vaccine. And so, a termination, if it did terminate your employment, it couldn't be for just cause, and therefore it would owe you severance. But if it provided you the option of retaining your job, provided you got testing, I said last week that if you refuse to get the testing, it's entirely possible then that would be a just cause termination. And one of you had said in the comments that another Samfiru Tumarkin lawyer had said that in fact that even if you refuse to get testing, that still wouldn't be a just cause termination. Okay, so and they said, well, the question was, how do you reconcile those two comments from lawyers from my firm? So the reason why it wouldn't be a just cause termination is because up until right now, so for the last year and a half during the pandemic, you've been doing your job. For most of you, you've been doing your job, and maybe you've been doing it with social distancing or PPE, or you're working remotely. And so if you've been doing your job this entire time, the employer can't turn around and say, okay, well, now you need to do X and Y and get a vaccine and get testing in order to keep your job. There's no... It doesn't have an argument in that sense, and therefore it can't terminate you for just cause, i.e. not give you severance. But you have to remember that judges they're people. Judges are basically trying to find the fairest outcome in the circumstances while weighing the competing priorities. And so while it is true that you couldn't have, for the last year and a half, you've been doing your job without getting COVID testing, and therefore your employer shouldn't be able to terminate you for just cause for refusing to get COVID testing. I can see a situation where a judge looks at that and goes, you know what, they're providing you a reasonable out. There's no reason why you shouldn't get COVID testing. So, I'm inclined to say that the employer had just cause to terminate your employment. There are going to be differences of opinion on these things, and because it's all brand new, we don't know how the courts are going to adjudicate on everything. We're giving you our best educated understanding pursuant to what the existing law is, but it is a brand new it's a brand new issue, and so there are going to be differences of opinion. But if the company if your employer is providing you an alternative, which is to get rapid COVID testing, I think that you're taking on more risk if you refuse to get that testing with respect to, do I get severance in the event of your termination? Okay. All right, so that was my primer. Went a little bit long. Let's start going through your questions here. I'm looking for advice if I don't know what that says, something home fires me or lays me off due to non-vaccine. What can I legally do? Okay, we just talked about that. So I think that I've addressed that question. In healthcare, my work says that they can mandate vaccines using Directive 6. Does that override our charter? Okay, I'm not familiar with Directive 6. I don't know what that is. Hospital and healthcare environments, actually, I don't know what Directive 6 is, so I'm not going to be able to comment on that. Charter question is interesting. So, the vaccine, so what the Charter of Rights and Freedoms does, and I'm certainly not an expert on the Charter of Rights and Freedoms, but it enshrines into our Constitution your Bill of Rights. So what that means is it's a set of freedoms that your government cannot infringe upon. Okay, and so there's a very good argument that, and this will be hashed out in our courts, that the various vaccine passports being implemented by Ontario and British Columbia and other places, in fact, violate those charter rights. And so that's going to get adjudicated probably all the way up to the Supreme Court of Canada. But your charter rights are only infringed. Let me rephrase that. Your charter rights only apply to you in a setting that the government is connected to, right? So if you work for a government entity, or if you work for a university, for example, and it gets government funding, then the charter may apply to you. But if you work for ABC Widget Company, the charter doesn't apply, and you don't have charter rights under that. So I hope that answers your question. I was laid off for 4 days. Can I claim for EI? I mean, are you back at work now? You can claim for EI for those 4 days, but you may not want to if you've returned to employment. But if it's become a termination, that would be different, right? So you have to, Scott, elaborate on whether or not you've returned to work. Is it illegal to take photos of coworkers who are not doing what they're supposed to be doing? I've never even encountered that question before. I don't know the answer to that question. I think that in an employment context, if it's the employer, I think it's incumbent upon the employer to get consent, to get your consent to not only take your photograph but to use it. But if you're talking about coworkers who are photographing each other and the employer has no bearing over it, I would think that if that's a problem for you, take your concern to your employer. And if your employer refuses to do anything about it, do you have any argument about, you might have a harassment argument because your employer has to provide you with a harassment-free, non-toxic work environment, and if it refuses to do so it knows that you're being harassed by somebody, and honestly, if someone kept taking my picture, that's kind of harassment. If it's if it has a sexual connotation, or if it's a man taking a picture of a woman repeatedly, I can easily see that being sexual harassment. And if the employer refuses to do something about it, you possibly have been constructively dismissed because it's not providing you with a non-toxic, harassment-free work environment. So I don't have all the information with your question, but I hope that answered it. What's the point of vaccines if they're not 100% accurate? And sorry, I'm having a hard time following the scroll. Why not use nanobots instead of vaccines? Okay, so that's a medical and political question, and I'm certainly not qualified to answer that. So for political questions, I mean, obviously it's a very politically charged time for many people. Those are questions I can't assist you with, but certainly you can avail yourself of your various representatives at the provincial and federal level, be it your MLA or your MP's office. We're a union hospital and the union sides of the hospital, so I'm not sure what to do. I can't really answer your union questions today. You need to take those questions to your union representative. So my employer said that the vaccines are not mandatory, but all of the unvaccinated will have different rules than the vaccinated. Is this discrimination, even though they said it's not mandatory to work? It depends what those rules are. It could be. So if the rules are adversely affecting you, it could possibly be discrimination on the basis of perceived disability. But with a lot of these things, the devil's in the details, right? Like, because going back to what I said earlier, judges are no different today than they were 1,000 years ago in England. It's a village elder, and judges are going to excoriate me for saying this, but it's a village elder who's very wise, the wisest person in the land, trying to make the fairest decision in the circumstances as circumscribed by whatever substantive law is, right? And so, if you have different rules, but the rules aren't too punishing or harsh, you might have a difficult time getting any legal redress, right? So, a lot of people will come to me and they'll say, well, I'm hopping mad because, the employer did X with respect to vaccines, but they provided you an outlet so that you don't have to do X. And when you look at that, it depends on how serious the employer's actions are in terms of how a judge is going to look at that. So I would very much encourage everyone to look at the seriousness of what the employer is doing as in terms of its infringement upon your rights and privacy, and then do they provide you with any sort of outlet to not have to follow any sort of mandatory procedures. Okay, so I work for a major Canadian financial institution, but work remotely. Could they make it mandatory even for remote workers? Does this make any sense? Okay, so one of the things I haven't said yet, and I don't know your name because I can't see it in your user. In all of this, for the vast majority of you, the best outcome is going to be to keep your job. Okay, you want to continue to work at your employer, and so an amicable solution is important. Is probably the best way to go. Now, for employees who are working remotely, there's no practical consideration as to why the employer would require vaccines for 100% remote workers, but that doesn't mean they won't implement it or they can't. They're your employer, and if they implement a policy again and then they terminate you because you haven't gotten it, you haven't followed the policy, then again you're in the same place which we were talking about before, which is what are your severance rights post termination? Does it make any sense? I mean, I can't comment on that. What I will say though is there's sort of a Canadian financial institutions, perfect thing to actually talk about this with. So there's immense pressure right now on all employers, particularly large employers, to have vaccine mandates. There's immense political and cultural pressure to do it. And so a lot of them are. But at the same time, we're currently in an age, in North America at least, where there's high rates of job vacancies. There are jobs everywhere right now. And a huge part of that is because the unemployment benefits that the federal government passed when COVID hit are still going to a degree. And so people are essentially or effectively being paid not to work. And so because of that, particularly in the United States, which I don't have any expertise on, but I am more familiar with the stats, there's a huge percentage of, I think there's something that's like 10% unemployment, but there's a huge amount of like 8% job vacancies that are being unfilled. And so, you're going to see those two imperatives come together where, employer thinks it needs to pass a vaccine, I shouldn't say pass, but implement a mandatory vaccine policy on all its staff. But at the same time, it can't hire enough staff to operate because there just aren't enough workers out there. And what do? And so I know from talking to some of my colleagues who work more on the employer side, who represent the large employers, that employers are grappling with this question, and some of them are electing to not implement vaccine mandates because they just simply can't. There's just not enough employees to be able to do that. If they lose, if you lose 20% of your workforce because you implemented as an employer, the employer implemented a mandatory vaccine policy, what business can survive that hit? So interesting things all around occurring. If they applied a new policy in the contract, which I didn't sign, related to vaccination status, is this legal to apply to you? So this is a really fascinating question. Or a very good question. So your entire severance entitlement is I shouldn't say entire, but there's a threshold question that you have to meet, which I'm not going to get into right now. But whether or not you get common law severance, which is sort of like big severance, or much smaller mandatory Employment Standards Act severance, is determined by your employment contract. Just to give you a weighing of it, Employment Standards Act severance is like essentially, I'm skipping over some stuff, but it's 1 week per year of service to a maximum of 8 weeks. So not very much. So you could be a 30-year employee and get 8 weeks. Common law severance is generally 1 month per year of service to a maximum of 24 months, and that's at your wage. So if you're making $50,000 a year and you were there for 30 years and you're 60 years old, then maybe you get 24 months of severance, so you'd get $100,000 in severance. Okay, so obviously a lot more than the 8 weeks. So So, if there's no COVID policy in your employment contract, then, as I was saying earlier, your employer can't just terminate you for not getting the vaccine and hope to say that it had just cause to terminate you. Just cause, again, just to remind you all, it means that you get zero severance. It's a rare thing, but it does exist, and it's the idea where the employer had a legally justifiable reason for giving you zero severance. Okay, and the law generally doesn't want that. They don't want you to get zero severance, but there are some situations where it is legally justifiable and makes a lot of sense, such as when the employee steals from the company or commits fraud or commits is indicted on some serious offense or punches his or her boss in the face, that kind of thing. So what this person is asking, Sura is asking, is that if they applied so it seems what they did in this situation is he or she is working under an employment contract that doesn't have any policies with respect to COVID-19, okay, and then the COVID-19 vaccinations, and then the employer wants to roll out a COVID-19 policy, and so they say, okay, well, everyone has to sign this new contract that has mandatory COVID-19 vaccines in the contract, so that if people refuse, they can be terminated. And she didn't sign the contract. Well, that's fine. That means that you're subject to the original contract still, and they can terminate you if they want for not signing the contract. But then your threshold severance of employment standards small versus common law big, is determined by what's in your original contract. Okay, and so I don't know what's in your original contract. It may be that you only get the Employment Standards Act minimums, but I certainly encourage you to contact us again at 1-855-821-5900 or help@employmentlawyer.ca, because you're going to want to have someone review that first contract before you sign it if you are thinking about not getting the vaccine. Okay, and I apologize to you all for not being able to get all your questions. There are a lot of them coming in, but we're going to continue to keep doing this. I think I'm doing this next Friday as well. So please join us next week. Look out for the link, and I'll try to answer as many of your questions as possible. And by the way, I was going to say this. I'm going to, because so many of your questions are about vaccines, I'm going to take the sort of the core primer that I gave you at the beginning of this, and I'll turn it into a little blog post, and I'll hopefully get that posted for you on the website next week. Okay, my boss has accused me of being rude in some of my emails. I've tried to make adjustments, but it's hard to avoid that interpretation at all time. Termination for rudeness is without cause, right? That's an interesting question. So, again, this is a just cause question. Just cause it's a high bar for employers, and the reason why is because it's a bad outcome for society if you're thrown out on the street with no money and no job. And so the law has evolved this idea that you're entitled to, we'll say, severance to tide you over, money after your termination or for your termination to tide you over until you get your next job. And so the law doesn't want to see you get zero, because severance serves a functional purpose, but it can in legally justifiable situations. And so there are two ways, there are actually three, but I'll talk about two ways to get to just cause. The employer can get to just cause. One is a single act on the part of the employee that is so egregious that the employer is justified no longer continuing the employment relationship. Again, that's, you come into work high on drugs or drunk, or you punch your boss in the face, you commit fraud, that kind of thing. The other is a series of a failure to meet ongoing employer expectations that you're provided clear warning of and an opportunity to correct. So that's your classic 3 written warnings and you're out. Okay, so those are the 2 ways to get there. So rude in your emails, if they give you a number of warnings and it's still not getting better, they can make the argument for just cause and terminate you. So if they write you up 3 times, 4 times, whatever, for being rude, and they stagger it at certain intervals, and it's always for the same thing, this so-called rudeness, then yeah, they might be able to terminate you for just cause. Again, as I said earlier, I think the devil's in the details. I think that if your emails aren't in fact rude, they might have a little bit of a tough time with that. And I'd certainly, if you were in British Columbia, because I'm only called to practice law in British Columbia, I'd certainly take your call and assess whether or not we could proceed in your severance claim. The other way, the single instance of your of rudeness. The single instance that's so egregious that the employer is justified in terminating the employment relationship. I mean, if in that case, it's much harder to get there. If you typed out in an email where you started swearing at somebody in all caps with exclamation marks and just sort of totally lost it in email, or called someone a racial slur repeatedly or something, that might also get you to just cause. And it sounds like from your question, these are not obviously rude, or at least in your opinion, they're not obviously rude emails. So it's just a question of tone. That would be almost impossible to get there. But things like racist language or screaming in all caps and swearing and exclamation marks, that certainly could get you there. But it's contextual. Just cause is contextual. So if you're a 1-year employee who's been written up for tardiness, your rude emails might get you to just cause. But if you're a 20-year employee with a clean disciplinary sheet, even the racist language isn't probably going to get you to just cause because it's contextual. So, okay. My employer is putting me on suspension as of tomorrow for not getting, this is from, so there's no name, for not getting the vaccine by today. I'll be suspended without pay until October 1. They are calling the next 3 weeks of voluntary resignation. Okay, so those are different things. So there's even if you're not laboring under a written employment contract, every single person who is an employee is working under a contract of employment, okay? And the core of that contract of employment is you go to work for a certain amount of hours for a certain amount of pay in exchange for a certain amount of money, okay? And unlike other contracts, like if I sell you my bike for $20, which is a one-time transaction, employment contract is ongoing, okay? So the employee is continuing to give you give the employer its labor, his or her labor in exchange for money on an ongoing basis. So it's an ongoing set of open-ended set of transactions, essentially. And so under that arrangement, the employer has no right at law to say, all right, well, we're just going to place you on suspension, unless it's in your employment contract, but that you agree to suspensions, but it rarely is. So it has no right at law to say, all right, well, we're not going to pay you anymore in exchange for your labor. Okay. So what I mean by that is just your suspension is very likely a termination at law. Whether or not it is, again, give us a call, 1-855-821-5900 to assess take a look at your employment contract to make sure that it is. You don't want to and just for all of you, before I finish answering this question, you should always talk to a lawyer before making decisions. I had a call once with a potential client, and he had called me after he'd made the decision to quit. And I said, well, what do you want me to do now? You've already done the thing. You could have spoken to me last week, and we could have assessed what your options are. But you made the decision before you spoke to a lawyer. If you can, always speak to a lawyer before you make a major decision with respect to your legal position at your employer. We're here for you. Contact us, help@employmentlaw.ca, and we'll certainly help you if we can. So voluntary resignation, that's a termination. Okay, so if they're saying, if they gave you a document that said you're suspended and you voluntarily resigned, that's a termination, and therefore you get into that severance analysis we talked about before. Can they say that you've been terminated for just cause? No. So it sounds to me like specifically you have been terminated, and you should definitely call us in order to assess what your legal position is with respect to your severance. Employer is not terminating employment, rather changed policy to unpaid leave of absence. That's exactly the same question as the one I just answered. If you are, what is unsaid there is that I think that it's not clear whether or not they have put you on an unpaid leave of absence, and I assume this is for not getting the vaccine. If that's the case, again, you can consider that a termination. Right? You can say, well, you know what, they had no right to, provided there's nothing in your employment contract that says they can put you on an unpaid leave of absence. There rarely is. Again, you want to call us. yeah, no, they can't just suspend your employment. So very likely you have been terminated. Okay, so I've been informed that we're almost out of time. We have less than a minute left, so I'm just going to say a couple of things. Number one, well, thank you all for joining us. We're going to be doing this again. I'm going to be doing this again next Friday, I believe, around the same time. Please join us again at that time. I'll take more of your questions then. Go to employmentlawyer.ca. Again, email us at help@employmentlawyer.ca. Call us at 1-855-821-5900. Quick questions at pocketemploymentlawyer.ca. I will do my very best next week to get you a brief written summary of sort of the core parts of the our position, my position on mandatory vaccines in the employment context, and I'll put that up on the website as a blog entry, and then I'll be happy to continue to take your questions next week. So thank you very much, everyone, for joining us. Great questions as always, and I wish you all a wonderful